Why is it that if the plaintiff has not filed with a claim against the trust, somehow the defendants are now unable to ask questions that would lead to the same evidence that they would get if they got the proof of claim form? I don't understand that. They still have the plaintiff in the tort system that they can depose. They have all of the discovery rules, whatever they are, that the court provides. And they can find out in that process everything that the plaintiff knows about the plaintiff's exposure. And based on that, they can do the same homework that the plaintiff's lawyer has to do and may not have been able to finish yet with respect to filing with the trust. But I don't see that there's a disconnect to me about in the argument that says, whoa, if they hold off and don't file the claims at the trust, then somehow the defendants are deprived of an opportunity to get information. They're just deprived maybe of the opportunity to have that information provided, gathered for them at no price from the plaintiff.
Well, Hugh, that is a distinction with a difference, because you all have successfully implemented limitations on deposition duration in most jurisdictions. In many cases, we have 1 day's deposition of a plaintiff, and with a 50 to 60 defendant case, that's a little crowded, even with those people who are named in the complaint. To get back to my earlier point, what we're really looking for is we can't sit down in a casual environment with your clients' clients, walk through the picture books, walk through things which are not on the Social Security report, not on the job site listings, and identify those claims. And since
Ain't that tough?
Well, it's more than tough, because we're worrying about and working with a dual system that shouldn't be separate. There's no justification for it being separate. It's an Alice in Wonderland situation. Here, all we're saying is you're the lawyers, you're going to prepare these people, you're going to help them identify their claims. We don't contend that the bankruptcy trusts are ATMs, because we do think substantive assertions as to causation and exposure are part of the claims process. And we think that's the core that we should be provided. Now, because of the e-filings process, and I respectfully disagree as to whether there are in fact effective statutes of limitations with the trust or not. In our experience, they're not, and certainly since our disposition of the average mesothelioma case in the system is about 12 months, I'm relatively comfortable that there's more time left to file claims against the trusts. And we all suffer, frankly, from this sort of bulge of new trusts coming online. It's a lot of money. It's highly significant. These are people who were co-defendants in the tort system when we all collectively lost control in the early 2000s. So they represent, from our perspective, a substantial liability share which has gone missing, which we've been forced to bear for the last several years, and which we don't think we should have to bear into the future. And we don't think, and obviously the plaintiffs' bar in West Virginia agreed with us to this extent, that any of this is onerous, unfair, a burden on the plaintiffs. All it does is take us back to a situation approximating the status quo ante, which is we have transparency and full discovery of all claims, so we can resolve all aspects of and again, it's a unified claim. We're talking about single injuries here in one proceeding, because the tort system does not allow us the assets or the mechanisms. And I don't think, Elihu, when you're talking about meso cases, which are the predominant cases in the system now, you want to relicense the defendants to do what used to be done 15 years ago, which is to get defense lawyers in a room and take 3 weeks of deposition from somebody who's dying. They're better uses of their remaining time.